Welcome in. Good to see you all. Get myself sorted out here. Here we go. Good morning, everybody. How are we doing? Hopefully everyone's okay. We have some news on the Georgia RICO case, everybody. And it's not great. It's not great news. I'll just leave it at that. It's not particularly good news. But what can we do, right? Hello, welcome. So, out of Georgia, everyone, we had multiple defendants who had questioned whether or not Miss Fonnie Willis should be disqualified. Now, Judge McAfee said, no, we don't need to disqualify her, but she needs to do a couple things to get it sorted out. That was appealed up to the Georgia Court of Appeals, and today, like an hour ago maybe, they have ruled to disqualify her. All is well. Well, so far, I mean, this is kind of a bummer for news. But yes, indeed. So I've not read through it yet. It's still hot off of the printer here, but I thought we could go ahead and take a look at what's going on. So let me write my little sticky note out here. So Georgia. Disqualified. Fonnie Willis. So let's take a look here. It really is. It's a shame, but you know, it's not unexpected. It was definitely a possibility. This could happen. They were working under the assumption of certain ethical rules, and she felt that she was fine, but they said she's not. And, you know, that's part of what our courts do, is make that determination about how things are supposed to work. So, no, the case is not gone. And in fact, the court said, no, we should not dismiss this case at all. They were very adamant about that. But she will be out. Now, I've not read through to see if her whole team is going to be out or not. We'll look through it here together. But, well, the thing is, they'll just pull in a special prosecutor, probably from another county, from another place. So I'm not worried the case will be gone, but her role in it will be. Right. Yeah, it feels that way. So let's go ahead and take a look, everybody, as everyone kind of comes in and joins. Let's see what we've got for the Court of Appeals. So they were supposed to hear oral arguments, but had canceled the oral arguments. So at this point, they just put their decision together here. Yeah, her whole office is out. That's what the request was. So let's take a look, everyone. I'm not going to read the entire thing. It's like 30 pages, but we can take a look and see what has happened here. So we have, let's just go through the list. Roman, Schaefer, Cheeley, Meadows, Trump, Latham, Giuliani, Clark, and Floyd. So again, around here, these are all the mug shots. So that's what they're referring to here. Oh, thank you. Tired of this guy and his cases. Oh my gosh. Oh, I know it. So we're at the second division here, the Court of Appeals. So they're listing everybody here and giving a little background. So the appellants were the ones bringing the disqualification question. They were charged in a 97-page indictment with RICO violations and other crimes in connection with an alleged conspiracy to unlawfully change the outcome of the 2020 presidential election pursuant to a granted interlocutory appeal, which means everything's paused while it gets appealed and decided on. The appellant's appeal from the trial court's order denying their motion to dismiss the indictment and granting in part their motions to disqualify the Atlanta Judicial Circuit District Attorney Fonnie Willis. So this is a sentence that's really important here. They are denying the dismissal of the indictment. They're just granting a part of it regarding her qualifications to do the case. All right, everyone. So the case is still going. The case is still is ongoing. And her office. So this is the piece too. So her office will be pulled from it as well. So they'll need to get a special prosecutor to come in, and that's really not that unusual. And actually, I think it will, maybe even be a benefit, so she doesn't get so tangled up in the case. Because we're supposed to be focusing on the case, right? But we've got all of these other things happening with the prosecutors and so on. So collectively, the appellants assert numerous grounds to reverse the trial court's order, including that the trial court imposed an improper remedy after concluding D.A. Willis's prosecution is encumbered by a significant appearance of impropriety, not grounded on mere status alone, but instead resulting from specific conduct impacting more than a mere nebulous public interest because it concerns a public prosecutor. In response, the state asked the court to affirm the trial court's order in its totality, including the imposition of an alternative remedy requiring that either D.A. Willis, along with the whole of her office, step aside and refer the case to the prosecuting attorney's counsel for reassignment, or Special Assistant District Attorney Nathan Wade withdraw from the case. Importantly, the state has not filed a cross appeal, asserting that the trial court's finding of this appearance of impropriety should be reversed, which is true. She did file a cross claim. Accordingly, whether the evidence presented to the trial court adequately supported under the appropriate standard of review of appeal, its finding of the existence of an appearance of impropriety is not before the court. Instead, we must determine whether the remedy fashioned by the trial court for this undisputed finding of significant appearance of impropriety was improper as contended by the appellants. So this is about the case that was, or the question that was right in front of them. Right. Yeah, the law's the law, and we don't use the term witch hunt on this channel, just FYI. So here we go, finishing on as we go through the rest of this. So appearance of impropriety, for the reasons explained below, we conclude that it was, and therefore reverse the trial court's denial of the appellant's motion to disqualify. We affirm, however, the denial of the appellant's motion to dismiss the indictment. So that indictment is not to be dismissed. Thanks, Kaya. I think we'll be okay, but how's this ruling apply to prosecutors but not the impropriety of the defense? Well, it wasn't raised, and that's what the court's saying here, that Willis's office didn't raise the issue that the appearance of impropriety that was found by Judge McAfee was wrong. They didn't say it was wrong. They didn't have a problem with it. So now we're looking at the remedy as to whether or not the remedy was appropriate. But yeah, she didn't plead against it. The motion to disqualify in special grand jury proceedings on January 24th of 2022, the chief judge of the Superior Court of Fulton County impaneled a special grand jury at the request of D.A. Willis for the purpose of investigating the facts and circumstances relating to possible attempts to disrupt the lawful administration of the 2020 election in the state of Georgia, including a decision by state Republican Party officials to draft an alternate slate of presidential electors. D.A. Willis served as the legal advisor to this special grand jury, which began receiving evidence in June of 2022. Around that same time, D.A. Willis hosted and headlined a fundraiser for an opposition candidate against Burt Jones in a lieutenant governor race. So this goes all the way back to her original ding that she got. This one, she was pulled because of this. After she later publicly identified Jones as a target of the grand jury's investigation, he and 11 other alternate electors sought to disqualify D.A. Willis and her office. based upon an actual conflict of interest. The Superior Court overseeing that special grand jury proceeding disqualified DA Willis and her office from any further criminal investigation or prosecution of Jones based upon a plain and actual and untenable conflict. So here is the reasoning for why she was pulled from the special grand jury. Good morning. Good to see you, everybody. It's reasoned that concern about the district attorney's partiality neutrally, immediately, and reasonably arises in the minds of the public, the pundits, and most critically, the subjects of the investigation that necessitates a disqualification. An investigation of this significance garnering the public attention it's necessarily does, and touching so many political nerves in our society, cannot be burdened by legitimate doubts about the district attorney's motives. The district attorney does not have to be apolitical, but her investigations do. So it's pretty powerful language. So again, because she had hosted this, fundraising event for someone, she was pulled from the grand juries, which actually turns out better in the end, because we don't have to toss out the grand jury findings that way. So that's kind of good. The Superior Court denied the motion to disqualify filed by the remaining alternate electors because they failed to show an actual conflict of interest with DA Willis or any member of her prosecution team. Its order did not explicitly address the appearance of impropriety as a ground to disqualify. After the special grand jury issued its final report recommending criminal charges against the appellants and others, it was dissolved on January 9th of 2023. So this is our introduction piece here. So motion to disqualify. Again, I'm going to kind of just run through this a little quickly here, but motion to disqualify following the indictment on August 14th. Willis secured a RICO indictment against the appellants and 10 others on January 8th of 2024. Roman filed a motion to dismiss the indictment and disqualify DA Willis, her office, and the special prosecutor Wade from further prosecuting this case on alleged grounds of conflict and an appearance of impropriety. Roman alleged a personal relationship between DA Willis and the special prosecutor Wade, along with the alleged personal financial interest in the case. After DA Willis spoke publicly in a church service on Sunday, January 14th of 2024, the other appellants also filed motions seeking dismissal and disqualification on the same grounds, as well as the additional ground of forensic misconduct in connection with the church speech and various other extrajudicial statements. The trial court's order on March 15th of 2024, trial court entered its order on the motions after conducting a multiple-day evidentiary hearing and summarized the issue in its ruling here. Wow, it was back in March. It seems like it was just yesterday, everybody. But it wasn't. It was back in March. As alleged, the claims presented a possible financial conflict of interest for the district attorney. More importantly, the defense motion and the state's response created a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedural due process. After receiving two and here we go, half days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence that they could muster, the court finds the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are also denied. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one or two options. The district attorney may choose to step aside along with her whole office and refer the prosecution to the prosecuting attorney's counsel for reassignment. Alternatively, the special counsel Wade would withdraw, allowing the district attorney the defendants and the public to move forward without his presence or remuneration. Sorry, everybody, I haven't had enough coffee. Distracting from and potentially comprising the merits of the case. So this is what Judge McAfee had ruled after they had that little like mini trial going on there. So, and then here's the citation as well. So let's skip a little bit here. They're just kind of giving us this background of how everybody filed all of their cases. And then they're talking too about expenditures. So we're going to kind of, all right. So here's another piece that I think is important. In addition, and much more important, the court finds, based largely on district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict or prosecute this case. So that's good. While a general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in any great need, as she testified that her salary exceeds $200,000 per year, without any indication of excessive expenses or debts. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. While prejudice is not a required element for disqualification, it is relevant to the considerations of due process and the defendant's requested remedy of complete dismissal. So remember, they did not just ask for her to be pulled. They said that because she should be pulled, the whole case should be dismissed. So defendants argue that the financial arrangement created incentive to prolong the case. But in fact, there's no indication that district attorney is interested in delaying anything. Indeed, the record's quite to the contrary. Before the relationship came to light, the state requested that the trial begin less than 6 months after the indictment. Soon thereafter, the state opposed severance of the objecting defendants who did not demand their statutory right of speedy trial. So again, they're going to go through and list out that the finances piece of it does not have any weight. So, although the trial court found insufficient evidence of actual conflict of interest, it also concluded the record made at the evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after Special Prosecutor Wade's initial contract in November of 2021, the district attorney chose to continue supervising and paying Wade while maintaining such a relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measures of reconciliation. This lack of confirmed financial split creates the possibility and appearance that the district attorney benefited, albeit non-materially, from a contract whose award lay solely with her purview and policing. So again, and then let's wrap it up here. Most importantly, were the case allowed to proceed unchanged, the prima facie concerns raised by the defendants would persist. As the district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade's patently unpersuasive explanation for the inaccurate interrogatories that he submitted in his pending divorce indicates the willingness on his part to wrongly conceal his relationship with district attorney. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think the district attorney is not exercising her independent professional judgment, totally free of any compromising influences, as long as Wade remains on the case. This unnecessary perception will persist. So then we noted, too, of course, that Mr. Wade had put his resignation in the very next day after this had been done. And then they're going to go through more of Judge McAfee's analysis here. So next up, it then rejected dismissal of the indictment and disqualification of DA Willis and her office upon the following reasoning. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness found here. There has not been a showing that defendants' due process rights have been violated, or that the issues involved prejudice the defendant in any way, nor is disqualification of a constitutional officer necessary when less drastic and sufficient remedial option is available. So that's Judge McAfee again, everyone, just saying, Wade needs to be off the case. That's remedy should have been fine. The district attorney's selection of whether Wade would withdraw or she would refer the case to prosecuting attorney's counsel for reassignment. All right, so they're kind of setting that up. Now, let's get into the Court of Appeals. This is Georgia here. As our consideration of the appearance of impropriety is limited to the remedy fashioned by the trial court, we turn to Georgia law on the issue. So this is where we're going to get a clarification here on what happened. Yes, Fonnie Willis has been disqualified in her office. They have been disqualified, but the indictment has not been dismissed, all right? While the parties advocate for diametrically opposed bright-line rules, disqualification of the district attorney's office can never result from an appearance of impropriety, or disqualification should always result when the elected district attorney engages in activities that raise the appearance of impropriety. Georgia law requires neither as a matter of course. So, again, there was this question of exactly where the line was when you have these kinds of personal relationships. So the court is setting out here, not necessarily that there's impropriety, but whether or not the remedy was appropriate. Instead, we must examine the particular facts and circumstances of each case while keeping some general principles in mind. First, the trial court's ruling on a motion to disqualify is reviewed for an abuse of discretion. So this is a question whenever a judge is involved here. Second, the issue of attorney disqualification is viewed as a continuum. So that goes here. And then they're quoting Georgia law here. Let's see here. We must address the remedy in the context of significant appearance of impropriety caused by the conduct of a public prosecutor. So let's take a look. This is a full quote out of State v. Wooten here. In our criminal justice system, the district attorney represents the people of the state in prosecuting individuals who have been charged with violating our state's criminal laws. The responsibility of a public prosecutor differs from that of the usual advocate. Her duty is to seek justice, not merely to convict. This special duty exists because a prosecutor represents the sovereign and should exercise restraint in discretionary exercise of governmental powers. Hold on, everybody, to drink some of my tea here. Therefore, the district attorney is more than an advocate for one party and has additional professional responsibilities as a public prosecutor to make decisions in the public's interest. In the district attorney's role as the administrator of justice, he or she has broad discretion in making decisions prior to trial about who to prosecute, what charges to bring, and which sentence to seek. So, our prosecutors really have a lot of discretion, huge amount of discretion. So they're going to go on and they're applying what Judge McAfee did. They're using the law and they're stating what they want to do here. After carefully considering the trial court's finding in its order, we conclude that it erred by failing to disqualify DA Willis in her office. So this is the key holding here, everybody. All right, the remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety. that existed at a time when DA Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. While we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated, and no other remedy will suffice to restore public confidence in the integrity of these proceedings. All right, so that's kind of a big deal here. Now, we do have this footnote, and I'll go ahead and get into that, and then we'll jump over to the conclusion here. But our opinions in Head v. State, Billings v. State, and Whitworth v. State are distinguishable. In Head, we address the appearance of impropriety based upon status alone, where the investigator with the alleged status conflict took no part in the investigation or prosecution of the case. Similarly, in Billings, the assistant district attorney with the appearance of impropriety did not participate directly or indirectly in the prosecution of the case after joining the office and of the district attorney. Here, on the other hand, DA Willis and Special Prosecutor Wade have been actively involved in this case from its inception. Division 1 of our opinion in Whitworth is non-binding physical precedent, and the case addressed only the disqualification of a special assistant district attorney. Likewise, the Supreme Court of Georgia opinion in Frazier relied upon the trial court. It's factually distinguishable and does not require a different result. The issue before the Supreme Court was disqualification of the entire district attorney's office based upon an assistant district attorney's conflict of interest rather than the conduct of the elected district attorney. All right, and then back up here into the holding. Accordingly, we reverse the trial court's denial of the appellant's motion to disqualify DA Willis and her office. So not just Fani Willis, but also her entire prosecution office here. As we conclude that the elected district attorney is wholly disqualified from this case, the assistant district attorneys, whose only power to prosecute a case is derived from the constitutional authority of the district attorney who appointed them, have no authority to proceed. So all of the other people in her office, she chose. So, they're saying she would have had influence on that. So the appellants contend that the trial court erred in denying their motions to dismiss the indictment. The state responds that the appellants have failed to show that the trial court erred in finding that the appellants had not shown their due process rights had been violated or that the issues involved prejudiced them in any way. Dismissal of an indictment is an extreme sanction used only sparingly for unlawful government conduct. In the absence of express statutory authority, dismissal of the indictment generally cannot be imposed absent a violation of a constitutional right. So this is why they're drawing this huge distinction. They're saying your case can't be dismissed, people. All right. While this is a rare case in which DA Willis and her office must be disqualified due to a significant appearance of impropriety, we cannot conclude that the record also supports the imposition of the extreme sanction of dismissal of the indictment under the appropriate standard. So that's huge. This now we've got a court of appeals in Georgia saying the case needs to go forward. All right. So that's pretty important here. We therefore affirm the trial court's denial of the appellant's motions to dismiss. So that works out great because we'll probably have other motions to dismiss coming as well. The appellant's remaining enumeration of error are rendered moot by our holding in Divisions 1 and 2. Judgment affirmed in part and reversed in part, with Judge Markle concurring and Judge Land dissenting. All right, so this is the dissenting opinion here. I'll just read you the beginning of it to give you an idea. Because the law does not support the result reached by the majority, ooh, that's big, I respectfully dissent. I am particularly troubled by the fact that the majority has taken what has long been a discretionary decision for the trial court to make and convert it into something else entirely. If this court was the trier of fact and have the discretion to choose a remedy based on our own observations, assessment of the credibility of the witness, and weighing of the evidence, then perhaps we would be justified in reaching the result declared by the majority. But we are not trial judges, and we lack that authority. Given the unique role of the trial court and the fact that it is the court which has broad discretion to impose a remedy that fits the situation as it finds it to be, we should resist the temptation to interfere with that discretion, including its chosen remedy, just because we happen to see things differently. Doing otherwise violates well-established precedent, threatens the discretion given to trial courts, and blurs the distinction between our respective courts. So that's the dissent, and then they go on here. So that is it for the holding. Boy, the dissent's really all up about it. About that trial court's decision should have been upheld. Goodness. So one concurring and one dissenting opinion, but voted for here. So there you have it. I dissent too. So there you have it, everybody. Miss Fonnie Willis has now been disqualified from the Georgia RICO case. But the court was clear the case should not be dismissed. The indictment needs to go forward. They just need to go talk to their attorney counsel and get the next batch of attorneys in on it. Yep. Oh, you're welcome. You're welcome. Now, when this whole thing hit the fan, my position on it was I didn't think that she had technically violated any laws. And I still don't. I still don't think that she violated laws. But I think that appearance of impropriety is so broad, and it's not specific enough for someone to say, well, this is an appearance of impropriety. It's very nebulous. So I think for them to use the impropriety piece of it was probably the only way to really pull her from this case. Yeah. So, there's good and bad with this. One of the bad things, of course, is that DA Willis is amazing, and she was just ready to go, full on, get her done, and we love that. But that stinks for her. So she's taken a huge hit here, huge hit. She'd already taken a hit with the special grand jury, and she's taken another one here. True, but on the other hand, the good part about this is that we now have a decision out of the Court of Appeals, which means the case can go back onto the docket again. All right. So once they're able to pull in another prosecution team, they're going to have to brief them all on the case and hand over the evidence, hand over all the research, hand over everything regarding the case to bring that new prosecution team up to speed. But then once that's done, then we're back on the docket. All right. So we're back on the docket. Any of the issues or motions or whatever can be resolved, and we'll be looking again at a trial date being set. And I think once our trial date gets set, truly gets set, we're going to see some more people pleading out. How long does this normally take? A new team? I don't know. This case is pretty, it's huge because we've got so many defendants, right? So we have so many defendants. We have 162 bad acts. We have 41 counts, although 7 of those have been removed by Judge McAfee. So they may try to refile some of those counts, actually. So it's a complicated case. And RICO cases are really complicated. They take a lot of work. They're just nasty creatures, but necessary nevertheless. Does the Supreme Court decision affect this case at all? Which Supreme Court decision, I guess? If you mean immunity, no. Immunity is not going to be put into this particular piece. And I can say that comfortably because we already have a decision from the DC Circuit explaining, candidate versus president. So we already have that. Who will take over? I don't know. But it sounds like they've got some kind of a board that does that. Now, in my state, I'm out in the sticks. So for us, whenever we need a special prosecuting team, you would just go over and have lunch and be like, hey, can you guys pick this case up? And then you spend a couple of days going through everything, explaining everything, and then the new team hits the ground running. But this is a huge case. We've got, this dude involved. So whenever he's involved, it always gets complicated. So I don't know. Would dating someone from her office be impropriety? So that's a really good question. And it seems like the Court of Appeals here really relied heavily on this question of if there was any kind of financial benefit. So I think if that piece hadn't been so kind of blurry in the gray zone, they may not have ruled this way. But it wasn't. So I think if you took out that financial piece and it was just a regular office romance, I think you'd be going down a little different road. Can new prosecutor drop it? Yes, it's possible. I'll be in Atlanta in January so I can interview attorney. Absolutely, John. Go get them. We need that. What would be a ballpark figure for sentencing if all found guilty? Oh my gosh, sentencing. Whoo! That I just don't know. I mean, we got to get this case to trial first. And which, in some respects, it's okay. I mean, this is good because we can move forward. We've been paused. We've been waiting to land the plane for a long time. Now the plane has landed. We need a new flight crew, and then off we go. But as far as the sentencing goes, I have no idea. I mean, we got to get it to trial first. We got to get it to trial. Mandatory minimum on a RICO is 5 years. So it would be more than that. Can new prosecutors drop it? Yes. New prosecutors can come in and dismiss the case. But let me remind you, we've had special grand juries pulled in and then just regular grand juries. And so to dismiss something where we've had multiple juries saying that there is probable cause, that's pretty bad form. And we don't like to do that because it takes away the power of our jury system, right? We're saying to the jurors, like, yeah, we see that you found there to be a problem and a violation, but we're going to just dismiss it anyway. So, yeah, won't Kamala be looking for work? Is she licensed to Georgia? I don't think she's licensed to Georgia. That's a good question, though. It's been a while, I think, since she's been in a courtroom. So, yeah. I mean, we've been waiting on this for a while, and so I'm really glad they didn't go forward with fighting over oral arguments because that just takes more time to. Everything's been briefed, everything's been set out. Judge McAfee's opinion was just very clear, crystal clear. So they were able to use that, of course, and to make their decision, right? Because a lot of discretion needs to be with the trial court. And the dissent here is saying that should also go to the remedy. But the majority of the court did not agree. The majority of the court said, no, we need to address the remedy, not the trial court. Mm-hmm. She'd hold her own. True story. Very, very true. So that's where we're at with the Georgia case, everyone. Again, this just has been released, made public just about an hour ago. What about the info supposedly from the White House? What? I have no idea. Michael, info from the White House? What? Yeah, this is its own entity. This case is its own case. They have their own spin on it to make it a Georgia case. So they're pulling Georgia law in here and applying whatever it is they need to it. So a lot of the acts involved here in this case happened in various places, true, but you only need 2 bad acts to convict in a RICO. So, they gave him 161 to pick from, I guess. And some of the other charges have been dismissed out of the indictment, so it's less than 41 counts now, but, there's still a lot of validity there. Yes, disqualified. Why does appearance of impropriety apply to the president? That's a great question. I don't know why it doesn't. It also doesn't apply to the U.S. Supreme Court. So that appearance of impropriety is, on its last leg, which is unfortunate. Short update, sure. So in Georgia, the RICO case for Mr. Trump and all of his people, I don't know, maybe they'll be his cabinet people now. Anywho, they had been charged with this RICO along with 41 counts. And so it had been on appeal because of the disqualification issue for DA Willis, because she had, office romance with the special prosecutor. And there's some question of impropriety. Was there impropriety or not? We don't know. And we're not going to find the answer to that. But there is the appearance. And so they pulled her and her team because the rest of the people in her team she will have hired, so they'll all be part of this. So the whole team is going to be kicked off as well. Yeah, people just kind of pick and choose apparently, apparently when impropriety is going to be used, and they're like, we're going to use it here. Can they get Jack Smith? Oh my gosh, that's a very interesting question. I mean, I think technically, as long as he could get like a special ruling to allow him to practice for this case, but wouldn't that be fun? Oh my gosh, that'd be so fun. That'd be really fun. He would have to have at least 2 to 3 fruit baskets, though, because he's worked so hard. Oh, he's worked so hard. Oh, sexism at play. Oh, absolutely. Absolutely. We have a very strong female prosecutor here. And so, the rules are different when you have that role in a male-dominated field. And we all know that. This is a male-dominated field in the legal world. And so, we're breaking glass ceilings with every step. And so DA Willis, yep, I think she definitely is a piece of that issue as well. Can they appeal this ruling? Yes, they can appeal it because they've got one more court to go. So there was the district court, which is the trial court, right? District court, and then we have the Court of Appeals in Georgia. And then in Georgia, we have the Supreme Court. So there's always 3 levels of courts that it can go to. So we're at the 2nd level here with the Court of Appeals. So there is a Supreme Court above this case. And it's possible that Mr. Trump and his people do appeal this because they were denied the dismissal. So they may want to appeal the dismissal denial. And Fani Willis may want to appeal disqualification as well. So they could both have grounds for an appeal. So we may not, it'll depend on how things go. She's the only one. No, her entire office is pulled because as the elected prosecutor, her job is to hire people, right? Or keep the people that have been there, whatever. It's all her choice on who her assistant DAs are. So all of those people then kind of are under her umbrella. Yeah. Yeah, I mean, it's not great. It's not great, everybody, but, it's also not the end. And, I think for this case, the clearer it can be, the best thing at all is to just make it absolutely perfect. So if there is this question on impropriety, you don't want to have the case go out and do the full criminal case trial and then have them come back and appeal the decision, appeal the verdict, right? Who can come in and prosecute the case? So it sounds like they've got a board. They've got an attorney board that they use where they've probably got, a list of all of the criminal attorneys in the state or in that region. And so they'll go through and take a look and see, which one might be best. Typically, you want to kind of stay in the same area. So, if there's other counties around Fulton County, typically you would want to pull someone in from there because of the practicality issue, because it will be tried in Fulton County. It's just they're bringing in a different team of prosecutors. He'd be good. Yeah, Jack Smith. I don't know. I think Jack Smith's earned a little vacay. This has been hard work. This has been really hard road to go down. What difference does this make if he's sworn in? So this is a state case, a state law that's been violated. It's not federal. So, nothing in Georgia law says that they can't go after a president. So, it can keep going on. Oh, thanks. Yeah, my phone rings. Yeah. pull it really, okay, yeah, exactly, VC. Whatever counties are close by, they can pull people from. But, they also have to agree to it. So they'll go to the prosecutors and be like, hey, here's this case, this RICO case, and it's a heckish nightmare that no one should have to deal with. But can you guys take it? Because we got disqualified. So they're going to have to agree to it. This will be a tough one. I don't know. If I was a prosecutor in the next county over, I'd be like, I'm not sure I'm going to answer the phone. Can they charge a sitting president? Well, he's already charged. He's already charged here in RICO. States can charge the sitting president. They don't have any, memo rules, unlike the Department of Justice. So the Department of Justice, of course, it's a federal agency out of the executive branch. So their rules are a little bit fuzzy when it comes to the president. But, in the state, with the state law, it's almost untouchable because it's the rule. That's the law there. Yeah, no, I would definitely not. I would not be answering the phone for a couple weeks. Will Elon threaten everyone? Probably. It seems like he likes to do that. Seems like that's a big whoop-de-doo for him. And that, as we all know, can sometimes happen. The only case I've cared about this entire time, and it's going to keep going. We're at a green light. We've been waiting for a couple months now, and also when this was first set out, it's been since this summer. We've been waiting months on this, but we finally have a decision now, and we should be able to go forward. Must blow up anything else today? That was a great question. Ford took pleas because they're smart. I agree completely. We had, just to kind of take you through the players, Mr. Cheesebro, who, by the way, has filed to have his plea agreement dropped so that he can come back with the others now that Willis is off the case. And the courts are like, no, we're not going to do that. So Mr. Hall here has pled guilty. Miss Powell here, also known as the Kraken, and then Jenna Ellis here, who had a very teary moment in court when she said she was sorry and that she made some bad choices. So Miss Powell wrote one sentence in an apology saying, "I'm sorry you feel this way," and assigned her name to it. But we still have Latham here, and she, I think, has the most charges out of anyone. We have several attorneys involved, Mr. Smith, Mr. Giuliani, Schaefer, which was one of the fake electors, Eastman here, who's lost his law license, Cheeley here, who I don't think he's lost his license yet. Here's Mr. Lee, he's a witness and a reverend. Here is Miss Hampton over here. She's kind of an accomplished, she wasn't a fake elector, but she was an accomplice to the situation. Then we've got Roman. He was like a staff, and it was his motion, actually, that asked for disqualification. So all of this happened off of his own motion. And then Jeffrey Clark here, who also has lost his law license. And then Mr. Still. Then Miss Cuddy here. She always looks so jolly. And then Mark Meadows, who's tried everything he possibly could try to get this case moved to federal court. And every single time they've said no, including the U.S. Supreme Court. And then Mr. Floyd here, who happened to be in jail the longest before he was able to bond out. So there you go. That's kind of our quick overview here of the Georgia RICO case. So the decision just came down just about an hour and a half ago. Miss Fonnie Willis, DA Willis, and her team are disqualified. So the case is not dismissed. The indictment is still good. They just need to pull in another team of prosecutors. I don't know how the payment's going to go on that, but I'm not going to worry about that. That's in the weeds. I don't know how that's going to get sorted out. Like, keep your receipt, people. Oh my gosh. Yeah, so I will put this, I have several things in my queue at my Tube of You to post, but I will post this probably just in a couple hours, the full live here. So in case for anybody that may have missed it, I am posting every day now on YouTube, so you can kind of hop over there and see what's up. It was disqualified because the media repeated. Well, maybe. Yeah, they might send it. Former governor testified. Yeah. I mean, it's a mess. It's a mess. Unrelated, but I tried press on recently. What's the best glue? Mine keep falling off. Oh my gosh, yes. So, nail break, everybody. The glue is really what's the most important thing. This is the glue I use. I order it off of Amazon, and it's waterproof. So I highly recommend this glue. This is not sponsored, but for me, this glue is the best glue, and I can get a week, sometimes even 10 days out of this glue, although I don't because I get bored. So I change my nails a lot. I change my nails a lot. Oh, absolutely. Absolutely. Yeah. It's in Amazon. It's on Amazon. So, yeah, I swear I've tried every single glue that there is, and that's absolutely the best. Does it work on eyelashes? No. Justin, no. You cannot put nail glue on your eyes. No, sir. Does the glue make the nails brittle? It can if you pull your nails off, and as opposed to soaking. If you just soak in some Dawn for a while, while you're watching whatever it is you're watching, then they come off very easily. Back to the case. Yes, Peter, thank you. There we go. We had our nail break. Now we're back in it. So, again, for anyone joining, Ms. Bonnie Willis and her prosecutorial team have been pulled off of the RICO case. Oh, so they've been pulled. Right. So they're going to have to get a new team in. They've got a board that they use down there, this attorney board that they were talking about. So we'll have to go to the board. And the board will have to come in and say, these are the people that can be available. So that'll have, not the nail break. I know. Oh my gosh. Yeah. So again, I'm not sure. I guess because we're kind of even in the middle of December, I would guess by the turn of the year, they'll have a prosecution team. So I don't think this is going to sit, in the hopper. I think they're going to definitely, maybe even by the end of the day, they'll have someone that's agreed to do it. But then the process of coming up to speed on a case that you've not been involved in since the beginning, because you have to understand, DA Willis and her team have been a part of this for years. So it's going to take them some time to get the new prosecutors up to speed. Still be doing this after? Yes, Grace, I will. I will be hopping over to the two of you. Yeah. And because again, I think their streaming works nicely. I tell you what, everybody, I wish I could get the Discord to work, but it doesn't, and bad things happen. So I'll be on the two of you. Never go to trial. Georgia will appeal. Well, I don't know. I mean, there's a couple of roads it can go down. Georgia or DA Willis can appeal. The other guys can appeal all the way to the Supreme Court. And the Supreme Court can be like, we're done. We don't want to deal with this. Or they may just continue to go forward. I mean, they've got other motions that need to get taken care of. So her and their staff product stands. Yeah. Oh, absolutely. Absolutely. I mean, they have put this case together in a way that, the next team that comes in shouldn't be too much trouble. It's just going to be a time issue. It's going to take some time. Pay for her. Yeah, exactly. No. Yeah. And it's, again, there's this question of would it have happened if it had been a man instead of a woman? And I think that's a really important question to ask. Very important. There is absolutely a double standard when it comes to that in the legal field. And the ladies were held up to a higher level that the fellas don't even realize are available. So that's a part of it. But, again, the case is still solid. The indictment has not been dismissed. They're very clear about that. It's just the appearance of impropriety with specifically in regards to the money situation, I think is really what tipped this one over. Matt Gaetz docs when they're available. Ooh, yes, I will. I usually don't like to swim around in the badness of the SA land, but with Matt Gaetz, I think it's very important. And I have done a live a long time ago on his friend that had already been sent away. So yes, I will be catching that for sure. Happy to hear you. Oh, yay. Well, hi, Mary. Good to see you. Yeah, I've got my morning voice. I tell you what, everyone, I sustained a vocal injury in college. So my voice was already on the outs. And then I'm still recovering from a cold. So I know it's got a swim through it. I will. I will. Who will get the case? We don't know. We don't know. Right now, there's a board, it looks like, that they use in Georgia, a board that comes together in order to choose who's up next. So that's what it sounds like is going to happen here. Let me see if I can find the name of the board. Just a moment. Let me see here. Trial court, district, in addition, right. Footnote here. Yeah, let me see. Here we go. Okay. Let's see. After careful consideration, I'm just trying to see what the name of the board was there. Now I can't find it now. I feel so much pressure right now. It's like the Queen song is in my head. Where's the name of the board? I can't find it. I don't know, where's that? I don't know. We'll just call it the Special Lawyer Board. We'll call it the Special Lawyer Board. Georgia's lawyer board. So they just pick from that. And then those people come over to the office and get debriefed. That's how it goes. Oh my gosh, I can't remember the name of the board. Who's got that? VC, where are you at? Where are you at? Come on. Help a girl out. What's going on? What's the name of the lawyer board? Oh my gosh. Oh my goodness gracious. Is that the one with the prosecution oversight and accountability? Sure, that sounds good. Let's go with that. Let's go with that one. So there's a special board and they'll pick the people. So, and it's going to take some prosecutors too. I mean, it's going to take a team. I'm looking, OVC. Oh my goodness. I know. What would I do without you all helping me? But yeah, so this is it's a pretty big deal. She's pulled from it, but the case goes on. So I think, I think it's okay. I think it's okay. It would have been better if we could have gone forward, but as the appellate court said too, what if we went forward, got a conviction, and then they appealed it? And they appealed saying that she should have been disqualified. Then we've got this huge RICO trial that's now in jeopardy because of that. So I think that's important to note as well. I mean, everything really has to be perfect when it involves Mr. Trump, right? It just has to be perfect. So I know. Oh my gosh. Oh, well, so there you go, everybody. I will make a little update post as well to kind of follow up on this. Would it be best if Willis didn't appeal, stayed off to prevent appeal problems? If she's going to need to make that decision, Chris, that she's going to need to really do some soul searching there. Is it worth it to do that and then try to get to a trial? Or, let's just get it done. What's the quickest way? So I think it'll be very interesting. Time is taking is damaging to... Yes, I agree. The time that it took for all of these cases involving Mr. Trump is very... frustrating, but I also think everything had to be perfect before anything got filed because, everything's going to be questioned here. Right. Exactly. So, yeah, it's very frustrating. It is. Prosecuting Attorneys Council of Georgia. Thank you, VC. All right. Now we know. We have an answer, everybody. Whew. I was really worried. So they need a man. Oh, I don't know about that. I don't know. Those words go together in a sentence. But we'll see. Yeah, look what they did to Jack Smith. Yeah, I mean, it's true, but I don't know. It's kind of like, it was bugging me up. Easy. That's funny. It was kind of like potatoes and tomatoes, right? I mean, I don't know if he wants to cross into Georgia law, but maybe he will. Maybe he's like, wow, I need, some kind of closure. Maybe, but who knows? All right, everybody, I'm checking out the time here and I should probably let everybody go, but thank you for coming by. I will be making again a follow-up post, and this live will be posted to my Tube of You. I'm posting there every day now, so you can leave comments over there and I will see them quickly, and have some content over there as well. So once I finish up here, I will make a new post, and yeah, I am waiting on Matt Gaetz. I'm looking at that. I'm waiting to see what's going to happen with that. I'm also looking at Giuliani. It looks like he may be going to trial actually in a few weeks. So taking a peek and keeping that on my radar as well. Yes, you're most welcome. Yes, and it's the same handle as it is here. So the same name and format over on my Tube of You. So have a wonderful rest of your day, everybody. And I will, puzzle piece. Dang, I thought we were going to get by without having to do the puzzle piece. Okay, we did it. Yay, us. Have a wonderful day. I will be back again very soon and go over the, I'm thinking about it. There's a lot of words that, I may not be able to do. I may need to just do that one over on YouTube. So I don't have to kind of censor my words so much. So, but I am looking at it. I'm just kind of seeing what's going on. It's a pretty interesting case, actually, how they've charged it. So take care, everybody. I'll be back again very soon. Have a wonderful rest of your day. Thanks for stopping by. And moderators, as always, thanks for your hard work.